You, without lawful justification and with the intent to kill, stabbed and cut Randy Gorey, thereby causing the death of Randy Gorey.
Really sort of hit it on the head. He not only embarrassed himself, he embarrassed all of the fine work, good off.
Like, man, he's hard to convince. That
look. Between August 2020 and January 2021, Jesse Mascarino Heidel carried out a wave of burglaries across Albuquerque, New Mexico, targeting homes in neighborhoods like West Mesa, near Sandia High School, and Tinoan East, often striking in the early morning hours. He broke into homes while residents were asleep, sometimes stealing vehicles along with valuables. Many of the houses were chosen for their location next to open spaces, allowing for quick entry and escape. Police eventually tied Mascarino Heidel to over 80 burglaries, though he admitted to roughly 28 after his arrest in January 2021. Surveillance footage and pawn shop records helped confirm his involvement. During questioning, he explained that financial struggles during the pandemic had driven him to commit the crimes. In March 2023, Mascarino Heidel pleaded guilty to multiple charges, including residential burglary, aggravated burglary with a deadly weapon, auto theft, and contributing to the delinquency of a minor.
I feel bad for that because I know how I would feel if somebody went into my house or somewhere that I was staying with my daughter there and with my baby mama there and everybody. It would have sucked.
You didn't receive an education, but clearly you're a smart guy. Anyone who organized this many burglaries is clearly intelligent, and I want you to keep that in mind, and I'd like you to pursue those education opportunities.
At sentencing, Judge David Murphy addressed the deep impact Mascarino Heidel's crimes had on victims, many of whom were left so shaken they moved from their homes, but also acknowledged his efforts to change, noting he had earned a high school diploma behind bars.
You didn't receive an education, but clearly you're a smart guy. Anyone who organized this many burglaries is clearly intelligent, and I want you to keep that in mind, and I'd like you to pursue those education opportunities.
Encouraging him to pursue education and become a better role model for his daughter, the judge recognized his intelligence and expressed cautious hope for his rehabilitation. He faced up to 20 years, but was given a 12-year prison term. In late 2018, Ramsey Bears, a former Miss Kentucky and middle school teacher in West Virginia, came under investigation after a parent discovered inappropriate images on their son's phone. The boy, a former student, had received several photos from Bears through a social media app. The matter was reported to authorities, and in December 2018, Bears was arrested and charged with 4 felony counts related to sending explicit material to a minor. As the legal process unfolded, Bears admitted to sending multiple photos over time.
I accidentally sent this young man a risky photo that was meant for my husband. The young man's name was listed next to my husband's name on my phone.
Initially, she claimed the first image was mistakenly sent and meant for her husband, but later acknowledged continuing the exchange after the student requested more. In court on December 17, 2019, she pleaded guilty to a single count of possession of material depicting minors in sexually explicit conduct.
Since I am the adult and he was just a teenager, it was definitely my fault, and I accept the full blame for the situation.
She expressed regret, saying she panicked and did not know how to handle the situation. Bears also mentioned that the student sent an inappropriate photo in return, which she neither saved nor distributed. Following her plea, she faced a minimum of 2 years in prison, the possibility of up to 50 years of probation, and mandatory registration as a sex offender. Between January 2022 and May 2024, Joseph Hefner, also known as Joseph Jones, allegedly engaged in inappropriate conduct with 2 sisters he met through his job at Discovery Playtown Daycare in Maple Valley, Washington. Hefner, who became a family friend, reportedly had unsettling interactions with the girls over a 2-year period at both their home and his residence. The incidents came to light on May 2, 2024, when the younger sister confided in a family member, leading to the older sister also sharing her experiences. Law enforcement was notified, and Hefner was arrested on May 31, 2024. Hefner, 25, has been charged with first-degree child rape, first-degree child molestation, and communication with a minor for purposes. He pleaded not guilty during his arraignment on June 13, 2024. Despite his attorney's request for electronic monitoring, the victim's father opposed his release due to safety concerns, and the judge ordered Hefner held on a $500,000 bail.
I feel that his release would be a danger not only to other kids, but it would feel like danger to my own kids. There was a huge sense of relief when they found out that he was arrested, and they still have trouble sleeping. I think that would make it even worse if they were to find out that he's able to get out on bail.
His next court date is June 25, 2024, with a jury trial set for August 5, 2024.
This is not his first conviction. I do not feel it would be safe for him to be out, period. There are kids that live in his apartment building.
It was also discovered that Hefner had a juvenile conviction for child molestation in 2012 and was a registered sex offender until 2021. This information was not revealed in the daycare's background checks as his juvenile record was sealed. The Washington Department of Children, Youth, and Families has since suspended Discovery Playtown's license. Between 2013 and 2015, in Spartanburg County, South Carolina, Jeremy Odell, then in his 30s, sexually assaulted a girl. The victim reported multiple instances of Odell touching her inappropriately over a 2-year period. Now, the victim suffers from PTSD and anxiety as a result of the abuse. In August 2024, Odell, who initially faced 5 counts of criminal conduct with a minor, entered a plea agreement. He pleaded guilty to a lesser charge of first-degree assault and battery, avoiding prison time.
Criminal sexual conduct with a minor, 3rd degree.
The victim chose not to appear in court, but provided a written statement expressing her disappointment rather than hatred towards Odell, which was read aloud during the sentencing.
I hold no hate in my heart for you, as I only remember you the way you were in my youthful years. I never knew you as I really matured, as my heart grew less soft. I find solace in that alone because I won't have to go on with my life feeling angry about what you did to me, only disappointed. I hope you've sat alone many nights, the same as me, searching for an answer your brain won't ever conceive, a why or what for. I hope you do better in the choices you make in the rest of this life and the next.
As part of the plea deal, Odell was mandated to undergo a psychosocial evaluation within 90 days, with the court to determine, based on the evaluation, whether he must register as a sex offender. During the hearing, Odell acknowledged the victim's account but declined to make a statement. Michael Sheehy, once a trusted Vienna Township police officer and school resource officer for Matthews Local Schools, had long been known for his dedication to law enforcement. In fact, he had been publicly recognized in 2016 for saving a man's life during an overdose. But that same desire to serve unraveled in late 2018 after Sheehy underwent ear surgery and was prescribed Percocet.
Eventually, the prescription ran out, and he had to turn to other means to support that addiction.
When the prescription ended, his dependence on opioids grew, leading him down a destructive path. Investigators later discovered that Sheehy had broken into his police chief's vehicle using department-issued tools, stolen cash, taken 2 weapons from the department, and trespassed on school property to commit theft. He was also found in possession of fentanyl, evidence of his growing addiction.
He did in fact use that position in relationship with both the school and the department to perform criminal acts.
By early 2019, Sheehy faced multiple criminal charges, including theft in office, breaking and entering, possessing criminal tools, and drug possession. He pleaded guilty to 7 of the charges in August 2019, with 1 felony charge dropped as part of a plea deal.
He stole from his chief, he stole from the department, he stole from the school, he used tools from the department to actually break into the chief's vehicle.
He's fully admitted that his actions were wrong, and he took ownership of this very early on in the process. He let his community down, he let his employer down, and he let his family down.
At his sentencing in December, the court acknowledged his early admission of guilt, but emphasized the serious breach of public trust. His attorney described him as someone who had always wanted to serve, but fell victim to addiction.
I let a lot of people down, especially those in uniform. And, for that I'm sorry.
Very rarely do I agree with what a defendant said, but in this particular case, Officer Sheehy really sort of hit it on the head, he not only embarrassed himself, he embarrassed all of the fine working and the good officers we have.
The judge sentenced Sheehy to 6 months in jail and 5 years of probation, warning that any violation could lead to prison time. He was also ordered to pay $1,700 in restitution, $1,000 to the school and $700 to the department. Gary Coleman met Shannon Price in 2007 while filming Church Ball, and despite a 17-year age gap, they quickly formed a relationship and got married later that year. Their marriage, however, was fraught with conflict from the beginning. In May 2008, the couple appeared on divorce court to openly discuss their problems, which included intense arguments, emotional outbursts, and incompatible views on starting a family.
I was scared you weren't going to come, because I understand you two got into an argument right before you got here and possibly weren't going to make it.
That was one of those ugly ones we have once a month.
Which we want to stop. We want to stop the ugly ones a month.
I'd like to stop it because I'm 40 years old and I can't do this for another 30 years.
You can't take it. What happened on this last ugly one that you usually have once a month?
Well, they're all different, but they're all centered around me. You know, the male is always the bad guy. The male is the one that's causing all the problems.
But you understood he didn't want children when you married him.
Right.
What did you think was gonna happen?
Probably.
Once you got married, what did you think you could convince him? You could talk him into it? You could oops it?
No.
And just accidentally have one?
No.
Yeah, that's the look I have on my face every day.
He's hard convincing.
Yeah.
He's hard to convince.
That look.
Price, let's talk about Mr. Coleman for a moment. You say he's got anger issues.
Yes. If he doesn't get his way, he throws a temper tantrum like a 5-year-old does. And he like stomps the floor and he's like, man! He starts throwing stuff around and he bashes his head in the wall too.
Shannon accused Coleman of having uncontrollable anger, claiming he would throw tantrums and even harm himself during fights. Coleman, visibly frustrated, expressed that the relationship was emotionally exhausting. Though they sought help on national television, their issues remained unresolved. By August 2008, the couple officially divorced, but their entanglements continued. Following Coleman's hospitalization in 2010, he filed a restraining order to keep Price from his home. After his death in May that year, Price claimed they had maintained a common law marriage, hoping to gain control over his estate. However, in 2012, a Utah judge rejected her claim, citing lack of proof and pointing to inconsistent cohabitation and evidence of emotional abuse and infidelity. The court ultimately upheld a 2005 will naming Coleman's former manager, Anna Gray, as the legal executor and beneficiary of his estate. In July 2024, Christopher Schaffer, a 38-year-old firefighter with the Columbus Division of Fires and a veteran of the U.S. Air Force, was accused of having non-consensual contact with a woman whose ability to consent was impaired. Following his arrest by Fairfield County deputies, he was initially charged with rape and released on bond. As the legal process unfolded, Schaffer was placed on administrative duty. The charges were later amended as part of a plea agreement in which he admitted guilt to 1 count of sexual battery and 1 count of gross sexual imposition, both third-degree felonies. On September 19th, 2024, he officially resigned from the fire department. On October 1st, 2024, a victim advocate read a statement detailing the emotional toll the incident had taken on the woman, describing her ongoing pain, confusion, and distress. Schaffer apologized, attributing his actions to alcohol abuse and calling it the worst mistake of his life.
Ever since that day, I have hurt in ways I didn't know was possible. A battle with extreme feelings of numbness and shock. I am overwhelmingly hurt, sad, angry, and confused. What he did was demoralizing.
I made the worst mistake of my life. I'm an alcoholic. I drank in excess and made a terrible mistake. I can't even begin to imagine the turmoil my actions have created and how it has impacted the victim.
You're right. You've disparaged the firefighters. You've disparaged the National Guard. You know all that. I mean, you had it all. You were serving this country. You had it all. And this is a primary example of how certain aspects of our life, if left unchecked, can ruin us. And in your case, you cite alcoholism, an alcohol problem. You know, I have a hard time believing that an alcohol problem can lead to something like this.
The judge, while acknowledging his military and firefighting service, emphasized that personal struggles like alcoholism do not excuse harm caused to others. Schaffer was sentenced to 3 years in prison and 5 years of post-release supervision. He is also required to register as a Tier 1 offender. Schaffer was taken into custody immediately after sentencing and will be eligible to apply for early release after serving 18 months. In Vernon Township, Ohio, 21-year-old Logan Stout came under investigation after authorities uncovered that he had been communicating online with a girl living outside the United States. Acting on this information, law enforcement secured a search warrant for his residence. During the search, investigators found 2 inappropriate images of the girl on his device. This led to formal charges filed through a bill of information, an alternative to a grand jury indictment when a defendant agrees to plead guilty. Stout pleaded guilty in court to 2 counts of illegal use of a minor in oriented material or performance. The judge sentenced him to 60 days in jail for the offense, highlighting the legal consequences of possessing explicit material involving minors, regardless of jurisdiction. In late 2017, as waste collection contracts in Idaquini were nearing expiration, the municipality urgently approved a 320 million rand tender without following standard procurement procedures. Officials claimed emergency circumstances justified bypassing protocols, allowing preferred contractors to be appointed directly. Internal processes were ignored, with a key city employee testifying that she was told to issue letters of award without proper approvals. The Integrity and Investigations Unit later received anonymous documents flagging irregularities. A forensic audit was commissioned and eventually escalated to the Hawks, revealing a network involving former Mayor Zandale Gumede and 21 co-accused, including senior city officials and contractors. They were charged with corruption, fraud, racketeering, money laundering, and violations of municipal laws. The trial began in the Durban High Court and has faced multiple delays, including health issues of witnesses and late document submissions. Testimony exposed how senior officials colluded to manipulate the tender, while the defense questioned the credibility of witnesses and investigative procedures. Meanwhile, the state seized assets, including 22 million rand worth of properties in Zimbabwe, linked to the accused. As of now, the case remains active, with witnesses detailing how the fraudulent tender was orchestrated and oversight mechanisms were deliberately bypassed, marking one of the most high-profile corruption cases in municipal governance. In the spring of 2021, a tragic encounter unfolded in Akron, Ohio, when 26-year-old Khalil Pau booked a Lyft ride. His driver, 48-year-old Christopher Rookie, a husband, father, and beloved community member from Hudson, Ohio, had no idea this would be his final ride. On the evening of May 2nd, 2021, as they drove along Buchtel Avenue, Pau fatally shot Rookie inside the car. Despite being gravely wounded, Rookie managed to drive a short distance before crashing into a utility pole. He was rushed to Summa Health Akron City Hospital, where he was pronounced dead. Pau was quickly arrested and faced a string of serious charges, including murder, carrying a concealed weapon, improper handling of a firearm in a motor vehicle, possession of a deadly weapon while under detention, felonious assault, and assault of a law enforcement officer. For a long time, he denied responsibility, prolonging the legal proceedings, but in May 2024, after over 3 years of legal maneuvering, Pau pleaded guilty to all charges in a Summit County courtroom. On May 16, 2024, during the sentencing, dozens of letters and a tribute video by Rookie's daughter painted a portrait of a man whose life brought joy and strength to those around him. Pau also expressed remorse, telling the court that his adolescent behavior and immaturity caused a lot of people great pain. Though Summit County Common Pleas Judge Allison McCarty acknowledged his apology and guilty plea, she reminded him that he had fought accountability for a long time.
So, Mr. Poe, it's been a long time that the court has been dealing with you. I've seen many sides of you. I hope you really listened to the statements of the family members and the friends today that spoke. I hope that you understand truly what you did. Your actions ripped a man from his family and obviously left what can only be called a gaping loss. I never met Mr. Rauke, but from having read the dozens of letters that were sent to me, I also watched his daughter's video that she made in tribute to him. I believe I've learned much about the person that you killed. And his family and friends described him as a family man, a ball of light, a softball and baseball super fan, a devoted son and son-in-law, a faithful friend, a loyal brother, a loving and devoted husband, and especially a wonderful father. Countless people have written to me to tell me about a time when they felt that they were hesitant or unsure about something that was happening in their life. They were lacking confidence or feeling low. And Chris Rauke shared his kindness with them and lifted them out of their problem. So it's quite apparent that on May 2nd of 2021, a shining light was snuffed out. What a loss to this community. Your evil action cannot bring back Chris. And while I do commend you for now pleading guilty to committing this murder, this court is also aware of how long and hard you fought to escape accepting such responsibility. I do want to say to family that from everything I've learned about Chris, obviously I did not know him, but I can say this to Madison and Tyler, I'm sure he would want you to stay strong, keep moving, excel in your sports and school, and continue to try to find joy in life. Ask for help if you need it, but keep looking for the good in this world. And for you, Mr. Poe, for the reasons that I've stated, I find that you are truly deserving of this sentence that I impose upon you now. I'm going to order that you pay the cost of this prosecution, finding that you will be indigent and incarcerated. I will enter judgment for that amount, but I will not allow it to be collected at a rate greater than $5 a month while you are in prison. As to case number ending in number 2188, which was assault on a peace officer, felony of the 4th degree, I will sentence you to 1 year in the Ohio State Penitentiary. As to the case number ending in 0563, possession of a deadly weapon while under detention, a felony of the 1st degree, I will sentence you to 11 to 16 and a half years in the Ohio State Penitentiary. As to the case number entering in 0749, the felonious assault charge, a felony of the 2nd degree, I will sentence you to 8 to 12 years in the Ohio State Penitentiary. Pursuant to the plea negotiation, I will run all of those sentences concurrent with each other. As to the 1791 case, count 1 murder, I will sentence you to life in prison with the possibility of parole after 15 years. I will also sentence you to 3 years for the attached gun specification. That is all mandatory time. In count 5, carrying concealed weapon, felony of the 4th degree, I will order forfeiture of the weapon in question, which I believe would go to the Akron Police Department. And Mr. Baumel, I'll ask you to give that information to the, so we can write that in the journal entry. And I will sentence you to 1 year on that. And to count 6, the improper handling charge, a felony of the 4th degree, I will also sentence you to 1 year. I will run those two one-year sentences concurrent to each other, but consecutive to the 18-year sentence attached to the life in prison sentence. That's a total of 19 years before you are eligible for parole.
Judge Allison McCarty sentenced Powell to life in prison with the possibility of parole after 19 years. The sentence included a mandatory 3-year firearm specification and additional concurrent terms for the other charges: 1 year for assault on a police officer, 11 to 16.5 years for possessing a deadly weapon while under detention, and 8 to 12 years for felonious assault. These were ordered to run concurrently with the life sentence. A separate 1-year sentence for improper handling of a firearm and another for carrying a concealed weapon were also imposed, but all sentences were structured to allow parole eligibility after 19 years. Pearl was also ordered to pay court costs, capped at $5 per month due to his incarceration, and his weapon was forfeited to the Akron Police Department. Today, Powell remains incarcerated, serving his sentence, while Rookie's family continues to cope with the irreplaceable loss of a man who meant so much to so many. In January 2020, 28-year-old Timothy Banowetz carried out a chilling attack at the home of prominent attorney Randy Gorey in Edwardsville, Illinois. According to authorities, Banowetz entered the residence and forced Gorey and his 2 sons into the basement at knife point. He tied them up and demanded valuables, including cash and electronic devices. Despite complying, Gorey was brutally stabbed. The boys witnessed the attack, were not harmed physically. After the murder, Banowetz fled the scene in Gorey's Rolls-Royce SUV, but was quickly located by law enforcement. He was found hiding in a wooded area nearby with a blood-stained shirt and a bag containing thousands in cash. Investigators later discovered a handwritten plan detailing his intent to rob, kill, and destroy evidence by burning the house. It was a calculated, premeditated crime that shocked the quiet community. Banowetz was arrested and charged with multiple counts, including first-degree murder, armed robbery, and unlawful restraint. However, in October 2021, just before the trial was set to begin, he unexpectedly pleaded guilty to 3 major charges: first-degree murder and 2 counts of armed robbery involving Gorey's sons.
At this time, Mr. Banowetz is going to enter into a plea of guilty to count 1 as contained in the indictment, being first-degree murder. The sentencing range on that charge would be 20 to 60 years. The state would agree to cap the sentence at 60 years. Then Mr. Banowetz would also plead guilty to counts 5 and 6 as contained in that indictment. The sentencing range on those sentences would be 6 to 10 years. Each of those charges he would receive day-for-day credit. Those charges would run concurrently with one another, but they would run consecutively to the murder charge. All remaining counts of that indictment would be dismissed per plea negotiations. We would ask that the court order a pre-sentence investigation and then set this cause for sentencing.
Mr. Harlow, is that your understanding of the plea negotiations?
That is correct, Your Honor.
Mr. Banowetz, is that your understanding of the plea negotiations?
Yes, it is.
Can you please remove your mask for the purposes of the plea? Thank you.
Yes, it is.
How old are you, sir? How far did you go in school?
I was in college.
Do you read, write, and understand the English language?
Yes, I do.
Are you under the influence of any drug, alcohol, or medication that would prevent you from understanding what we're doing here today? Do you suffer from any mental condition that would prevent you from understanding what we're doing here today? You have been charged in count 1 with the offense of first-degree murder. The charge alleges that on January 4th of 2020, you, without lawful justification and with the intent to kill or do great bodily harm to Randy Gorey, stabbed and cut Randy Gorey about his body, thereby causing the death of Randy Gorey in violation of 720 ILCS 5/9-1A1 and done against the peace and dignity of the people of the state of Illinois. Do you understand what they say you did in that count? In count 5, you're charged with armed robbery. That charge alleges that on January 4th of 2020 in the county of Madison, You, while armed with a dangerous weapon, a knife, took property, being a cellular telephone, from the person or presence of a minor child, being Ethan Gorey, by the use of force, in violation of 720 ILCS 5/18-2A1, and done against the peace and dignity of the people of the state of Illinois. Do you understand what they say you did in that charge? Yes. And in count 6, you are charged with armed robbery. The charge alleges that on January 4th of 2020, in the county of Madison, state of Illinois, you, while armed with a dangerous weapon, a knife, took property, being a cellular telephone, from the person or presence of a minor child, with the initials GG being Grace Gorey, by the use of force, in violation of 720 ILCS 5/18-2A1, and done against the peace and dignity of the people of the state of Illinois. Do you understand what they say you did in that charge? Knowing that I will bind myself to the negotiations which involve caps in this case, how do you wish to plead to those 3 charges, guilty or not guilty?
As part of a plea agreement, the state agreed to drop the remaining charges and cap his prison sentence for the murder at 60 years. The robbery charges each carried a sentence of 6 to 10 years, to be served concurrently with each other, but consecutively to the murder sentence. In December 2021, Banowetz was sentenced to a total of 70 years in prison, 60 years for murder, and an additional 10 for the robberies. Under Illinois law, he must serve the vast majority of his sentence, making the possibility of release remote. A year later, in December 2022, Banowetz attempted to withdraw his guilty plea. He submitted a handwritten motion claiming he had been coerced and didn't fully understand the consequences of his plea. He also accused the judge of bias. However, the motion was filed long past the legal deadline and lacked credible evidence. After a hearing in November 2023, the court rejected his request, reaffirming that the plea was entered voluntarily and with full understanding. In 2024, Banowetz pursued an appeal, but his public defender concluded that the appeal lacked legal merit. The appellate court gave him a final deadline to respond, but no further legal relief followed. As of now, Timothy Banowetz remains behind bars at Pontiac Correctional Center, serving a 70-year sentence. All attempts to challenge his conviction or reduce his sentence have failed. On August 2, 2017, 21-year-old Savannah Gold disappeared shortly after arriving for her shift at Bonefish Grill in the Mandarin neighborhood of Jacksonville, Florida. Surveillance footage later revealed that moments after parking her car, she entered a vehicle belonging to her ex-boyfriend and co-worker, Lee Rodart. What initially looked like a brief conversation quickly turned violent. Inside the vehicle, a struggle occurred. Rodart was seen driving off with Savannah, and soon after returned to her parked car, where he slashed one of the tires, possibly an attempt to mislead investigators or stall the discovery of her disappearance. For days, Savannah's family and the community searched for her. Then, on August 5th, 2017, Rodart was brought in for questioning. After hours of interrogation, he confessed to killing Savannah and led detectives to her body, which he had disposed of. In the years following Savannah's murder, the case made its way through the court system.
Again, State of Florida versus Lee Rodart. This is case number 2017 CF7212. We are here for a sentencing hearing. The court will note for the record that on February 15, 2021, Mr. Rodarte entered a plea of guilty to the crime of second-degree murder. The court accepted his plea of guilty. Sentencing was deferred until today.
In early 2021, Rodart agreed to a plea deal. He pleaded guilty to second-degree murder in exchange for a negotiated sentence. On March 11, 2021, during the sentencing, Savannah Gold's family delivered deeply emotional victim impact statements. Her father, Daniel Gold, spoke of her strength, creativity, and passion, remembering her as a fearless girl and gifted athlete whose life was stolen far too soon. He expressed guilt and sorrow over not being able to protect her.
Your Honor, on April 26, 1996, my life forever changed when I saw Savannah. I instantly could see how beautiful she was. Her extremities were perfect, 10 fingers and 10 toes. Also, she had chubby round cheeks I couldn't wait to squeeze. Her real beauty lies within her true colors. She had the heart of a lion and the presence of the rising sun within our family. Within the first 6 months of Savannah's life, her lion's heart was on full display. She developed septicemia when she was 10 days old from a kidney infection. It seemed to come out of nowhere. One minute she was fine, the next she was comatose. That was the most terrifying day of my life. I never felt so helpless. On August 2nd, 2017, that feeling of helpless terror returned and Savannah went missing. Lee took Savannah's life on August 2nd, 2017. As I watched the video of Savannah struggling for her life, Lee's car violently shaking back and forth, I saw her lion heart in glowing colors for the last time. As a parent, I've always hoped my children would find something they love to do and for them to be able to do it. Savannah was a very gifted artist and athlete. For me, it was easy to see her gifts. Savannah was very critical of herself as an artist, but as an athlete, she beamed with confidence.
Her brother Chris recalled her competitive spirit, their holiday memories, and the emptiness her absence has left, admitting he has lived in emotional isolation since her death.
Savannah was a hard-working person who would do anything for anyone. She was a perfectionist who strived to only do something if she knew she could give it her all. She was passionate about everything from sewing to lacrosse. She was so passionate about lacrosse that she would upset if she played bad, even if she won. After lacrosse games, she would have blisters on her toes from driving so hard on the ground. That passion was infectious. People always tried to do better when around her. I always stepped up my game when she was around. For example, when we worked together, she was Employee of the Month twice and I was never even nominated. It's not the only time she outshined me. She learned how to ride a bike the same year I did, and she was 6 years younger than I am. Hell, she learned how to wakeboard before I did. But looking back, it's quite impressive. I was always amazed how she was always to do the best thing. No, that's fine. It's hard to put in words what she meant to me. And it's hard to say to strangers what she meant to me. So unfortunately, my memories of her accomplishments are all I have left. I remember waking up with her on Christmas morning and walking out to the living room. One of my fondest memories is on Christmas Eve. One of my fondest memories is on Christmas Eve when my sister learned that my parents had bought her a cherry red Volkswagen Beetle. She cried when she found out they had been hiding in the backyard the entire time. She and I then went to an abandoned parking lot so I could show her how to drive stick shift. Yet again, she picked it up quicker than I did, and she was doing donuts within 20 minutes in that same parking lot. That might sound extreme, but to us, it was the best way to spend Christmas. When we were kids, she would sneak into my room on Christmas morning. Years later, I was showing her how to have the most fun of her Christmas gift. The holidays have not been the same, nor will they ever be. In fact, my family and I try to keep the holidays to a minimum.
Ms. Gold, will you please introduce yourself to the court and let us know your relation to Ms. Savannah Gold?
My name is Sharon Gold. I'm Savannah's mother.
And have you prepared a victim impact statement?
I have.
You can please read that at this time.
Savannah H. Gold was our only girl and second child. She was taken from us when she was 21. How could we ever imagine the impact 21 would have on us? 21 was her jersey number in sports. 21 tattooed on her hand in Roman numerals. 21, the year her killer goes to prison. She had a full life ahead of her, full of opportunity. She did not get to experience the most beautiful part, finding her path, the joys of parenthood, finding her purpose, her passion. When she was born, the doctor put her on my chest to say hello. She was so perfect, her big fat cheeks and little attitude. I loved her immediately. I finally got to meet the person doing aerobics in my belly. Moments as a toddler were fun. She was fearless with boundless energy. By the time she was 3, she would jump in the deep end of our pool and swim all day long. I'd imagined she would someday join the circus as an acrobat because she had so much joy doing flips off the diving board, trampoline, and in gymnastics. Savannah loved to draw pictures. As a young child, she would go through reams of paper with her drawings. Everywhere you looked were Savannah's drawings. In middle and high school, she auditioned for and got accepted into the art magnet schools. That's where she discovered her love of fiber.
Her mother, Sharon Gold, described Savannah as a vibrant, empathetic soul who once cared for her during cancer treatment and mourned the future Savannah was robbed of becoming a mother, fulfilling her dreams and living a full life.
And the court has accepted Mr. Rodarte's plea of guilty. In connection with that plea of guilty, there was a negotiated sentence, and that negotiated sentence was an adjudication of guilty on count 1 of the information filed against Mr. Rodarte, which is a count for second-degree murder. That involved a sentence of 40 years in prison with credit for time served since August 5th, 2017. In connection therewith, the state had agreed to drop counts 2 and 3 with the imposition of court costs and the public defender's fee. And we had a waiver of the pre-sentence investigation report as well. We have determined restitution. So with that said, Mr. Rodarte, I'm going to sentence you to the negotiated sentence in this case, which is to reiterate an adjudication of guilt on count 1 of second-degree murder. And in connection with that adjudication of guilt, I will sentence you to 40 years in the Florida State Prison. You will receive credit for time served since August 5, 2017. Ms. Williams, what are the court costs due? There will be $518 of court costs imposed and a $150 public defender's fee. Are there any surcharges, Ms. Williams? Additionally, restitution will be ordered to the Victims' Compensation Trust Fund in the amount of $1,299 and separately ordered to Sharon Elizabeth Gold and the Victims' Compensation Trust Fund in the amount of $8,962.69. Mr. Rodarte, do you understand that sentence?
Judge Jeb Branham sentenced him to 40 years in state prison with credit for time served since August 5th, 2017. The charges of evidence tampering and abuse of a corpse were dropped as part of the agreement. On the evening of June 16, 2023, 29-year-old Derek Thompson was behind the wheel of a rented Cadillac Escalade, speeding north on Interstate 35W in Minneapolis. Witnesses and traffic cameras captured him, weaving recklessly through traffic, reaching speeds exceeding 100 miles per hour. Without slowing down, he exited onto Lake Street, ran a red light at 2nd Avenue, and crashed violently into a Honda Civic carrying 5 young Somali American women: Sahra Gazadeh, 20, Salma Abdikadir, 20, Sagal Hersi, 19, Siham Odhoa, 19, and Sabirian Ali. All 5 were killed instantly.
Sergeant, in that video clip, Exhibit 125, did we see the crash itself occur?
Yes, we did.
And just prior to that crash, did you observe the driving behavior of the Honda Civic?
Yes.
Did it appear to be traveling according to the posted speed limit in the area?
Yes, it appeared to be traveling the same speed and like all the other vehicles that were before it.
Did it appear to enter the intersection on a green light?
Yes, into the intersection on a green traffic signal.
Did the Cadillac Escalade appear to be moving at a very high rate of speed?
It was moving at an extremely high rate of speed for the speed limits in that area.
And did it enter the intersection against a red light?
The group had been out that night preparing for a friend's wedding, having just gotten henna done. It was meant to be a joyful occasion, but in an instant their lives were stolen. After the crash, Thompson fled on foot, only to be found a few blocks away, hiding near a Taco Bell. despite denying involvement and attempting to blame someone else. Body cam footage, witness accounts, and forensic evidence confirmed he was the driver. Blood and spatter analysis from the vehicle, along with surveillance footage and testimony, left little doubt. Thompson was charged with 5 counts of third-degree murder and 10 counts of criminal vehicular homicide. During his trial in June 2025, jurors watched harrowing body cam footage, listened to crash reconstruction experts, and heard deeply emotional testimony from families. One of the most powerful voices was Rukia Gasada, the younger sister of Sarah, who described her sister as a selfless, intelligent young woman, close to graduating with a degree in health sciences. Sarah had dreamt of becoming a doctor. Her sister recalled everything they had done together growing up, learning to ride a bike, going to school, and staying up late studying. That future and those memories were now shattered.
How did you first learn that she had passed away?
I first learned that she passed away that same night. I was sleeping. I came back from work around like 8 p.m., I would say. And I came home, I was sleeping, and I was woken up by my 2 brothers. And they were like, hey, we gotta go. And when we left, we got in the car, and it didn't feel good. I could tell that something was up.
So as you got in the car and you were driving somewhere else, you didn't really know the full scope of the situation? Is that
No, I didn't know.
Did you know that something had happened with your sister, Sarah?
Yes, at that time I did know that something happened with my sister Sarah, and I knew some of the girls that were in it, but I didn't know if it was them for sure or not. But I did know for sure that my sister was amongst them.
Your brothers wake you up, you get in the car, you're going to go to another location.
Yeah.
Where did you guys go?
So at this point, we got in the car and we were driving to Lake Street, where the accident happened.
And what did you see when you got there?
At that point, I heard the news pretty late. I wasn't there in the beginning of when everybody got there. I came around 2 a.m., I would say, so pretty late after the crash. And when I went there, I just saw a lot of ambulance, yellow tape and so yellow tape, ambulance, people crying, but I don't really 100% know that they passed away just yet at this point.
Did you find out at some point while you were on scene?
Yes, people were coming to me hey, sorry for your loss. So at that point I figured out that Sarah passed away. And then I wasn't too sure who was in the car at the time. So they were just telling me the names of a couple of my friends who were also in the car.
So I want to go back a little bit. Do you know what your sister was doing that night? What brought her to that area?
Yeah, so that following morning, she dropped me off at work in the morning, and she was just telling me about hey, I'm gonna go get henna, and I'm gonna go with her friends after work. I told her, hey, I can do your henna for you, but she insisted. She was I'm gonna go with my friends. So I didn't know that she was gonna go to Caramel and get her henna done with her friends at the time.
What's henna?
Henna is it's body art, kind of not a permanent tattoo, but it's it leaves after about a week.
And was there any special event or anything coming up where she wanted to have the henna done?
So there was a wedding on the following night, the next day, but they never made it. So.
Do you know whose vehicle was being used by Sarah and the other girls?
Yes, the vehicle was the vehicle that we have at our house, the Civic, that we shared here and there. When she came from Rochester from school, she would use that car, but mainly me and like my siblings would use it.
But it wouldn't be unusual for Sarah to use that car?
No, yeah.
The defense tried to suggest that Derek's brother may have been driving, but jurors were not convinced. The physical evidence was overwhelming.
We, the jury, in the above entitled matter as to count 1, murder while perpetrating an eminently dangerous act and being indifferent to the loss of life in the death of Sarah Gasade, find the defendant guilty. We, the jury, in the above entitled matter as to count 2, criminal vehicular homicide for operating a motor vehicle in a grossly negligent manner in the death of Sarah Gasade, find the defendant guilty. We, the jury, in the above entitled matter as to count 3, criminal vehicular homicide for causing a collision and leaving the scene in the death of Sarah Gasade, find the defendant guilty. We, the jury, in the above entitled matter as to count 4, murder while perpetrating an eminently dangerous act and being indifferent to the loss of life in the death of Siham Odawa, find the defendant guilty. We, the jury, in the above entitled matter as to count 5, criminal vehicular homicide for operating a motor vehicle in a grossly negligent manner in the death of Siham Odawa, find the defendant guilty. We, the jury, in the above entitled matter as to count 6, criminal vehicular homicide for causing a collision and leaving the scene in the death of Siham Odawa, find the defendant guilty. We, the jury, in the above entitled matter as to count 7, murder while perpetrating an eminently dangerous act and being indifferent to the loss of life in the death of Salma Abdikadir, find the defendant guilty. We, the jury, in the above entitled matter as to count 8, criminal vehicular homicide for operating a motor vehicle in a grossly negligent manner in the death of Salma Abdikadir, find the defendant guilty. We, the jury, in the above entitled matter as to count 9, criminal vehicular homicide for causing a collision and leaving the scene in the death of Salma Abdikadir, find the defendant guilty. We, the jury, in the above entitled matter as to count 10, murder while perpetrating an eminently dangerous act and being indifferent to the loss of life in the death of Sagal Hersey, find the defendant guilty. We, the jury, in the above entitled matter as to count 11, criminal vehicular homicide for operating a motor vehicle in a grossly negligent manner in the death of Sagal Hersey, find the defendant guilty. We, the jury, in the above entitled matter as to count 12, criminal vehicular homicide for causing a collision and leaving the scene in the death of Sagal Hersey, find the defendant guilty. We, the jury, in the above entitled matter as to count 13, murder while perpetrating an eminently dangerous act and being indifferent to the loss of life in the death of Sabreen Ali, find the defendant guilty. We, the jury, in the above entitled matter as to count 14, criminal vehicular homicide for operating a motor vehicle in a grossly negligent manner in the death of Sabreen Ali, find the defendant guilty. We, the jury, in the above entitled matter as to count 15, criminal vehicular homicide for causing a collision and leaving the scene in the death of Sabreen Ali, find the defendant guilty.
On June 6, 2025, after nearly 2 days of deliberation, the jury found Derek Thompson guilty on all 15 charges. Judge Michael Burns scheduled sentencing for July 24, 2025, and prosecutors have already indicated they will seek a longer, enhanced sentence beyond standard Minnesota guidelines. Meanwhile, Thompson is also awaiting sentencing in a separate federal case from 2024, in which he was convicted on weapon and drug charges. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.